as things get more and more advanced, they're getting to where they're starting to infiltrate, carriers, and they can find out what policies you have, and then they will go after the companies with cyber policies, because they know there's an insurance backing that ransom.
It's not. I mean, I'll tell you, it's not dumb.
No, it's not dumb.
No, it shows a level of sophistication on there.
But it fights against the notion of having a policy, because now you're the ones being attacked. So you got the coverage, and now you're the one.
I feel like these aren't teenagers in basements. This is probably a little more advanced than that.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi, good afternoon, everyone. Welcome back to another episode of The Defense Never Rests. I am Nate Bolander, filling in probably incapably for the unparalleled Megan Henry, who is off today. People always say that on the news. So she's off today. I'm filling in. We have two guests today, Matt Margolis, who's the Director of Risk and Legal Management for Lloyd Jones, and then Corbin Bashford, who's the Director of Claims for Marsh McLean Agency Mid-Atlantic. We're going to talk today about the plaintiff's bar versus the defense bar with respect to kind of changing times and how both of those bars kind of are adapting to things as they change in the legal landscape. We've had Matt on before. He's well known for his TikToks, his legal TikToks on LinkedIn, and he's getting really notoriety for that. And it's well deserved. He's a really, really funny guy, and really, I've prognosticated before that he's going to be governor one day or something. He's got so much personality. And then and Corbin is just a fantastic guy. He's with a brokerage, and so he's going to kind of explain what a difference between a brokerage and a claims handler would do, or an insurer would do. And we're going to talk about nuclear verdicts. We're going to talk about social inflation. Corbin handles claims all over the country, so he's going to talk to us about different venues that he deals with. So we're in for a real treat. Please subscribe and like this. Leave a comment for us. And without further ado, let's dive right in. And we're happy to welcome in Corbin and Matt to the Defense Never Rests. How you guys doing?
Great.
Yeah,
Matt is a repeat guest, back by popular demand. So we'll get to him in a second. But Corbin is the new guy, so we'll start with him. Give us your position and what you do and what that means.
So I am currently the claims director for Marsh McLennan Agency Mid-Atlantic. I have a team of 6, soon to be 7. We oversee any and all claims issues for our clients. So any mid-market commercial clients that we have, anything from cyber to general liability, auto. If there's any issues that need advocacy for our clients, we'll use it there to advocate and fight for our clients.
And are you in specific silos of claims? Like, some people only handle certain types?
No, we actually handle everything. Anything and everything you can think of, will funnel to our team. I have 2 folks on my team who do specialize in executive lines, which are EPL claims, cyber, and then D&O issues.
What's the most exciting? Cyber would seem to be like, is it why?
Right.
It's the hardest to hold on to. I can't keep up with all the changes. Every time we turn around, something's new.
Is it just the technical aspect of it, or the way at which technology adapts and increases?
And it's the way they're finding new ways to attack through cyber. And we're also facing an internal conflict of now these hackers are attacking insurance folks with insurance policies. So they're going to carriers, attacking their networks, pulling all the insurance policies, and making demands for those limits. Now that they know, so they're not. Yeah, it's becoming a growing issue, so that's why cyber rates are skyrocketing.
So you're saying someone will attack a company and pull, they'll pull XYZ policy for that company there.
Yep.
It's that sophisticated.
Yep, they are getting to the point now that as things get more and more advanced, they're getting to where they're starting to infiltrate, carriers, and they can find out what policies you have, and then they will go after the companies with cyber policies, because they know there's an insurance backing that ransom.
That is blowing my mind.
It's not. I mean, I'll tell you, it's not dumb.
No, it's not dumb.
No,
it shows a level of sophistication on there.
But it fights against the notion of having a policy, because now you're the ones being attacked. So you got the coverage, and now you're the one.
I feel like these aren't teenagers in basements. This is probably a little more advanced than that.
I was laughing at the emails from like the Nigerian prince scams, or like I have a boat in Holland, help me, the lawyer. And there's these guys that are like, all right, I'm just going to steal all these policies from whatever insurance company.
Wow.
It's crazy. It is crazy.
Wow.
But
So
that-
how do those work? I mean, it's just you have coverage for this, and so the policy's triggered and it's paid, or I mean, I'm sure there's some fighting.
There's a lot of fighting. There's a
Yeah.
lot of requirements that it could probably be a whole separate podcast on, and I am not the one to do it. But
Okay.
there are so many intricacies to the cyber policies. I think there's 14 insuring agreements that can be put on a cyber policy, all covering different types of attacks, different types of information. You have to select kind of what level of coverage you want. So it all varies, but cyber, it's becoming a huge issue.
And there's probably some argument to be made, or that some people are probably saying that there's a disincentive to have that coverage because they're being targeted, right?
Yep.
I mean, it's like, right, exactly. It's like, well, we had the foresight to do this, but now we're getting on the back end, we're getting hit more than other folks.
And the premiums are going through the roof. So it's becoming it's not advantageous anymore, almost not, to not get the policy because you're paying premiums that are outlandish. And at the same time, you're the one being targeted.
Is this like the pipeline? And Matt, Matt, you and my jobs are not as exciting. I know that.
Oh.
Based on
This is so intriguing to me right
Yeah.
now. This is blowing my mind.
Yeah. So is this like the pipeline that was just held for ransom? Is that the type of thing that you would deal with on a regular basis?
Yep, similar. We do it just every day. But we have, here at Marsh McLennan Agencies, we have two special folks who handle specifically that realm of coverages because we need someone who specializes in that area. With it changing all the time, with the amounts being demanded or policy limits, so it depends. Millions, you deal with millions of dollars every time. So we have two specialized people for that very reason.
Are those people like IT?
No,
folks,
they're claims folks. They're specialized in the cyber claims handling, not necessarily. Now they're becoming better with technology as they dive into this every day, but they're focused on the claims aspects of anything with cyber.
Wow. All right. Well, so that segue, Matt, let's talk about you and I. Not nearly as exciting. He's got Corbin's got the screen behind him. It looks like NORAD. Yeah. He's probably doing cyber. I have a light switch. You have blurriness. I mean, like this.
I blurred it because there's a bench press behind me.
Yeah. For those that don't know, before we got on, Matt had all this workout equipment back there. It looked like Gold's Gym, so we blurred it out. But so
it's
Matt,
really just.
Yeah, exactly. So let's go with your your background. So quickly, I know you've been a guest before, but we like to give a background on guests.
Yeah,
so how
sure.
did you where are you and how did you get there?
So I'm the director of legal and risk management at a private equity developer known as Lloyd Jones. How I got here is I've been a defense attorney for most of my career and eventually specialized more or less in construction and risk management inside of construction. I took that and now I'm in-house and living the dream, man.
So what is the decision I know the jump from firm to in-house is like the dream. It's like jumping out of an airplane into a cloud. For some people, they say it's amazing. So why did you choose to do that? Is that something you sought after for a while?
So it wasn't originally, right? Because it's such a, I don't know, it's such an internal struggle, right? You're like, there are two paths that you were taught in law school. You're either going to be the partner of a law firm, right? You're going to be a big shareholder with either the big book of business, or you were the quintessential trial attorney or the specialist, or you went in-house and you're the general counsel or assistant general counsel and you're really the corporate side. And man, it was a struggle, right? It's like the angel and the demon.
Yeah.
I guess the angel and the angel. But I thought about it and I'm starting a family and I figured, it would be great to take my talents in-house, like LeBron would say, I'm taking my talents to Miami.
Yeah, this will be your announcement. We'll do like I remember they were like sitting on benches in that gym when you made that announcement. So you're taking your talents to Lloyd.
Can you imagine the TikTok and memes I'm planning in my head for LinkedIn right now?
Yeah, you got dust you can throw in the air.
Yeah, that's right. Yeah, I can't wait for that. Listen, if they were really exciting before, I can only imagine what you can come up with next. Some big ones in-house. Woo!
I know.
How about it?
Game changer.
Yeah. So what was the main driving force you to make one reason why you made the decision to make the jump? Was it the family and more time thing?
Yeah, that and speaking kind of to you, Corbin, like the inside claims perspective, like managing the claims, I find that so fascinating. Really managing risk and managing an insurance portfolio. I love being an attorney, but I mean, that is It is cool. It's really cool,
Exciting.
right? So that was obviously, another portion of the reason why I left or went
Yeah.
in-house.
That's exciting. Well, congratulations. That's great. Two big pieces of news. You announced you were having a child, and now you're announcing you're going in-house all in a month.
It's all strategic. I'm trying to keep
Yeah.
building the
I'd
momentum.
say, yeah, couldn't let me have this moment. Yeah, took it away.
What
Didn't do it,
next?
man.
What are you gonna do in August, Matt? You gotta
I don't
top
know,
it.
man. I'm running for governor of the state of Florida. And
Yeah, well, your governor down there is under some fire, so maybe you could just slide right in there and start your
yeah,
campaign.
man. I don't know if I'm destined for politics. I've said it before. My parents always wanted me to be a weatherman.
Yeah,
So maybe that'll be the announcement in August. I'll be that dual JD meteorologist.
never seen one. I've never seen one. That's
Yes.
great.
It's new. It's new. It's
Yeah.
hot. It's hot right now.
Yeah, and in both professions, you could argue you're always wrong no matter what you do.
That's
So
true.
That's
It's always great.
Yeah, always.
But
Yeah,
it's
it
really
always
fun.
depends. That's right.
That's so
Um,
funny.
Well, so Corbin, for folks that are watching, I think folks who are watching know claims and they know what attorneys do and everything. But what does a broker do? You said you were the brokerage. So what does that do? How is that different from those
So-
two roles?
We take, if a company comes to us, they say, essentially, this is what we do as a company. These are all the facets of our company. These are all the inner workings in what we do. So then what we do, or our producers do, the salesmen, is they actually meet with them. They go through what they do, and then they try to match the insurance coverage for what they need to protect them. So that, up to the limits, any self-and retentions, if they want to join any captives. And then from there, once they bind the book of business, and then, they shop that out with a bunch of carriers, once they get the best rates with the best coverages, which we also do focus on customer service that they're going to get in the long run. It's not just the numbers, because we want to make sure that when we put them with a carrier that they're going to get the product that they're owed. So once it is booked, then we come in on the claim side for all the moments that matter. When stuff goes wrong and you need somebody to advocate for you, that's where we jump in. If you think you've got a coverage denial that's not accurate, or you're not getting responses from your carriers, that's where we jump in and we start pushing the envelope the best we can.
That's
So
awesome.
so you deal with kind of the communication between the insured and insurer. But what about just handling of a claim day to day? So let's say there's a claim, let's say the insurer picks it up and you're going forward with litigation on that claim. Are you day to day being reported to and everything? Are you kind of in the background monitoring?
We can be, depending on what the client wants. If the
Okay.
if the client's happy and content with what's going on, they don't need us to oversee the day to day, then we won't. But if things get a little fuzzy and we need to start monitoring it more, then we'll start picking it up and just keeping tabs on what's going on. We don't directly handle claims. We're not adjusters. We just advocate. So we push the ball where we think things need to get pushed by the
Right.
carriers.
And do you get asked all the time, or do you ever affirmatively watch a claim and say, we're going to make the decision? If so, how do you make that? Who makes the decision? How do you determine that?
So I won't track it unless it's either, like, if it's a large claim that comes in, I'll keep an eye on it, just
Mhm.
because I want to make sure that things are going smoothly, at least until I know that it's with an adjuster, they're handling it appropriately, and then maybe I'll peel back a little bit. But if a client comes to us and says, hey, I'm not getting what I think I need, or I'm not getting responses, or this coverage issue, then we'll jump in right away. But a lot of it is alerting from the client. They do a lot of self-reporting. So, but we'll obviously help with that as well if they need to.
Right. And Matt, I'm sure when you were doing your defense work, you would report to brokerage folks as well as
All,
claims handlers.
yeah,
Yeah.
all the time. First, I gotta say, Corbin, that is the coolest thing. It's such a value-added service you provide.
Thank
I mean, listen, I did this last one. Shout out to MMA.
Yeah.
Great brokerage. So
Appreciate that.
yeah, man. So listen, there was plenty of times where, as defense counsel, on any sort of big, especially like you described, Corbin, like really big claims you're monitoring, it'll be defense counsel, it'll be a broker, and it'll also be the claims person. And listen, they were out to bat for their insured or their client, all the time. So I always respected seeing the broker on there that honestly took a real, I guess, advocacy, I can't even speak, position.
Well, I couldn't say
for their,
report, so I think you win because you're a couple more syllables, so you're fine.
What day is today, man?
It's
Yeah.
Tuesday.
Well, I'll ask Corbin this in a second, but Matt, did you ever see a disconnect between the broker and the claims folks? Like, I'm sure they probably talked separately, but I've never seen in my life in front of me, even on a call, that they disagreed.
I've seen some brokers disagree on certain positions
Okay.
in a positive direction, right? Like, because
Right.
it's always I'm always my client, I'm working for my client. I have seen it every so often. And listen, I'm for it. I'm liability counsel, right? I'm not coverage counsel, so
Right.
I like hide.
Right.
But I have seen it before, and it's been listen. It happens. It happens.
And Corbin, is that pretty common? I mean, do you
All
guys
the
have
time.
behind the scenes, like if you have I imagine a round table before mediation or trial, and then you guys go in your room and you're like, wow, we don't agree on this and we better hash it out.
We will, it happens all the time. We disagree with, not all the time, I won't say all the time. It happens periodically where we disagree. But a lot of times we'll have those conversations direct with the carrier too. We'll pick up the phone and call the carrier and just try to walk through why they are where they are and then explain why we disagree. But we also will explain to our clients if coverage is denied and it's the accurate and it's the right decision by the carrier. Part of our job is also explaining that to the clients
Right.
that, this is not covered. And that's probably the most difficult conversation to have in all these, in all these conversations. That's the toughest one.
You probably had some contentious back and forths that way because it could mean a lot of money. Yeah.
It's most of the time it's folks who have paid a lot of money for premium and they're facing an uphill battle, with a lot at risk. So it's tough. It's a tough scenario.
Yeah, I have a case right now with I represent one defendant. There's another defendant. And, coverage was disclaimed for both of us, and we're facing a significant award, and it really changes the equation with how you go about things.
Changes the landscape.
And that disclaimer letter is that what you call? I mean, we call them disclaimer letters. That's the death knell a lot of times, and you just hate getting those.
Yeah, we see a lot of disclaimers. I've been seeing a lot more general RORs being sent lately. Just as soon as there's any issues, they just will, send a blank ROR, essentially just saying we reserve our rights on everything until we figure out what's going on.
Right. And how are those received?
They're filed, and then we wait for an official position, or if we don't get one soon, we'll push.
Yeah.
You copied and pasted a number of exclusions to this piece of paper. What does this mean?
A lot of it is just, we're not sure what's happening here, but we're going to reserve our rights until we figure it out.
Right. Corbin, so we were talking beforehand, you're an attorney, so give me give us kind of the background of how you became where you're at. I know you had a bunch of different career moves to get.
Yeah. So I started off actually when I graduated law school in 2015, and I started off on the plaintiff side. Did that for a little less than a year, realized it was not for me. Wasn't great for my conscience. So I transitioned over to James River, and I was on the Uber account as an adjuster for litigation and coverage issues, and then ended up as an assistant director there when we actually dropped the Uber account, and then migrated over to Selective, where I did general liability for a year, and then was recruited here.
Nice. Now, did you ever think when you were a plaintiff's attorney, I don't like this, it's not fitting with my ideology, so let me go to the defense side and be an attorney? Or why did you go from that to claims?
Well, so before I went to law school, I actually worked at Geico handling personal auto claims. And that was kind of the driver to get me. I was like, man, I see what these attorneys are doing on the plane. So I could do this all day. This is easy. And I'm making way less. But then when you get on there, it's just not, for me personally, it wasn't all that it was cracked up to be for me.
Right. And we were talking beforehand that usually it's the opposite. Usually a defense attorney will go plaintiff side for money. And then, but ideologically they might not be there because they are so used to the defense side and it's tough to switch over, but the money's too good, or they're starting a family, they want to have some more means.
And a lot of times they make the best plaintiff lawyers. They know what the defense does.
Yep. Yeah, absolutely. I know a really good plaintiff attorney in Philadelphia who was a claims guy for, I think, 2 decades. And one of his taglines I'll never forget on his website is like, I know the opposite side in and out. So I know. So he told me, we had lunch one time and he said, listen, I know as soon as I pick up the phone, I said, what are your limits? What's your umbrella policy? What's this policy? Have you tendered? Who do you tender to? And I think plaintiffs attorneys don't often ask those questions up front, but this guy knew exactly who had the coverage, why, when. He dismissed these players. He kept these players in because he knew where the pot was at the end.
And I think that's how Morgan was started. They started with a bunch of defense lawyers, and now they're huge, especially down your way, Matt.
Yeah, where's the headquarters? Orlando, right?
Yeah. Oh yeah. I've had plenty of claims with some really good Morgan attorneys. And a lot of them, they're a blast to work against, I guess. Right. We may be on different sides of the V, but we're all working together, right? I mean, it's how it works. I want to go back for a second, Corbin, because you made a pun. I don't think you realized it. It's a driving factor right after you were referencing Geico. I caught that, man.
Oh wow. Yeah. Was that on purpose?
I unknowingly slipped it in.
I was going to say, was that on purpose?
Not intentional,
was-
but I'll take it.
Okay, good.
as a future father, respect. That was a
Yeah,
great dad joke.
Appreciate that.
Love it.
Yeah. That your dad jokes increase tenfold.
Yeah,
Is that how it works? It just
Oh,
like
yeah.
it just
The
turns
day they
on.
come out, dad jokes flow.
yeah. Well, when I was in law school, I turned 30, and I'm 28 or 29, and my friend said I lived with. He said, "Hey, can you help me move this desk?" And I moved it without his help or something. I was much fitter back then. He said, "Wow, it was right after my birthday." He said, "Wow, I guess you have grown man strength." And I said, "What do you mean?" He's like, "You know how old grown men can just lift things. You know, like you get to be a certain age, you can lift anything you want until you get to be like 60, and then you can't lift anything." But I it's the same way. Like when you become a dad, you probably have those puns, and
Oh, yeah.
when you get to be 30, you just all of a sudden can like lift everything.
I'm going to start picking up heavier stuff.
There you go. Well, yeah, exactly right. Matt,
That's why I got the bench press behind me.
is
Yeah.
that why? But
Save
see,
it.
that's not like real. I've always been told that if you lift like weights, you're getting what's it called? You just look big, but
Oh,
you're not
show-
actually strong.
Show
not-
muscle.
Yeah.
Yeah. Show
Yeah.
muscles.
Yeah. So I was told like flip tires around. I remember when I was in high school, I did you remember Mike Allstott, the fullback for the Buccaneers?
Yeah.
Oh,
I
yeah.
did the Mike Allstott workout one day. Threw up all over my high school campus. My friends are pushing cars and flipping tires, and I was like 135 pounds, and I was like, no, I just threw up. We all were just sick as dogs. But so that lasted one day.
I'm as big as a tire, so I don't know if it'll ever work out for me.
Well, you not at the beginning of COVID, you said you were all
Yeah.
you were all cut up. So
Yeah, well, yeah.
It just fades.
Maybe it's a little talk, maybe it's not. Who knows? Listen, I'm an attorney. Isn't
that's
it?
right. That's right. Yeah. So Matt, at least for me, I love working with claims folks that are attorneys too. I mean, I think that I've never really been like challenged in a non-cordial way. I mean, they're like, did you consider this? Did you consider that? It's almost like having another colleague that you can bounce ideas off of. And I love it. I mean, I think some people say, well, I don't want to be questioned, and I'm handling the legal side, but I don't agree with that at all. I think collaboration is far better. And I don't know if you had ever dealt with that.
Oh yeah, absolutely. Yeah, you're right. It is like a colleague, especially. I mean, especially a lawyer claims person who also was working on the defense side. There's plenty of that I've seen where it's like, well, working at a very large defense shop and go in-house with the client. You're right. It is always very cordial and collegiate, and it's like, hey, you want to shoot for an early mediation? And I look at the other side, like, yeah, let's shoot for an early mediation. And it is like a collaborative effort. It is a blast.
Right. And I think those folks just know more about what you're going through because they've been through it. And so I think that's great, Corbin, that you have that training in the back of your pocket too. Got to help out day to day.
Yeah, it's helpful. I know kind of at least a little bit of what drives the plaintiff side, which I think we all do.
Yeah. And speaking of which, that's a perfect segue into our topic. We want to really talk about was the state of the plaintiff's bar and the state of the defense bar. And we talked beforehand, Corbin, about the plaintiff's bar kind of being more advanced or having some more strategies that they employ than the defense bar. And I guess I'll just start. Do you think that's a true statement? Do you think that the defense bar is advancing more, the plaintiff's bar is advancing more than the defense bar, over year after year?
I think so. I mean, they work together. For the plaintiff's bar, they have essentially unlimited clients.
Mm-hmm.
Every person out there who's been injured by anything is a potential client. So they work together very well. They develop strategies together. They have summits where they'll meet together and kind of round table ideas, and they have the listservs that we talked about. The defense side doesn't necessarily have that because there's a limited client base. And it's that collaboration, I think, gives them a huge advantage, along with other things that, we'll get to down the road. But I do think they continue to advance because they continue to work together and collaborate.
Right. And Matt, would you agree with that? I mean, do you see that in Florida that over, years practicing, the plaintiff's bar has always come up with new things they can bring up, and the defense bar kind of doesn't meet that the same way?
Couldn't agree more. I think you'll see complaints drafted and look very similar to other complaints. You'll see certain arguments presented that are very similar to other arguments, and it's almost like it's like evolution, right? Like certain arguments will evolve and the best argument survives and everyone will pass it around.
Yep.
But you're right, on the defense side, you're right. You may work with 4 or 5 carriers and you work for 4 or 5 carriers. And I don't want to cross-pollinate any ideas or any, I really don't want to talk strategy or talk shop because of fear of someone poaching a client or whatever. You're right. So all these defense shops are more or less siloed from each other and they can't grow like that.
Right. We internally all the time in our firm we just got one this morning from our insurance coverage person. Have you ever seen this? And we had a big discussion on email amongst all the attorneys about that email. and we have a biweekly meeting where we bring this stuff up. But in terms of, and we obviously have contacts in the defense world that specialize in things. So, if I have an aviation case in Buffalo, then and I had co-counsel, we got along really well, or another defense counsel I got along really well, I'll call them for an issue, but there's no kind of, it's all one-offs, right? It's all, I know that person, this person's, I feel like the plaintiff's bar has this listserv, and I know about it because at least in Philly, I've not seen it live, but I mean, everyone talks about it. And every time you have a win, a good argument, you win a hearing, and information about it just gets uploaded to this. And it's just this huge collaboration. I was talking to Corbin before the podcast started. Every plaintiff's attorney in Philly, at least, loves each other. I tell a plaintiff's attorney friend, I have a case with Jim and Tom and Joe, and I love all those guys. I'm like, well, didn't they just took your clients on this one case, didn't they? Or you guys disagreed on? Yeah, but we're all, I mean, I think that's the baselines are all making tons of money, and life is good. I mean, they're on their boats and life is good. And I mean, Corbin, you and I were chatting about that before. Is that what you kind of see as well?
Yeah, it almost seems it's less stressful. I mean, they make obviously lots of money with their clients, and they just seem to have a lot less pressure on the day-to-day from my perspective. I feel like the defense side faces a lot more restrictions and regulations and fear of a nuclear verdict or a, cases going awry than the plaintiff's bar. I mean, what real downside do they have by taking a case to trial and losing? I mean, it's not humanizing the person anymore. Now it's more of just a collective, oh, we lose this one case, doesn't matter. But I don't think the plaintiff's bar is really looking at the person anymore necessarily, that individual and their injury and what they need. So on our side, we face more pressures day to day. And we talked about bad faith. And I think that also goes to it too, where bad faith is now being used as a weapon or a tool against carriers, as opposed to its original design to punish carriers when they act egregious. Now we have to go to seminars on how to avoid traps. This is not the intention of bad faith, is to trap carriers.
There's certain things out there that I think they're supposed to be used so sparingly. I bring up punitive damages all the time. I've had several complaints lately where punitives are thrown in, and it's thrown in not with a separate count, but with the word recklessly or the word intentionally or maliciously or something, wanton behavior. And if you don't notice that, and I've seen, I'll PO it, I'll do preliminary objections, and another defense counsel will answer, and I'm like, I guess because there's no punitive count, you got too many cases, you're just answering so quickly. But so Corbin, what is a bad faith claim, and what does that mean when you say that's triggered?
So all states have unfair claim practices acts. They, each state has their own set of rules that carriers must follow. Essentially just saying that they are going to adjust your claim in good faith. We are, despite what the plaintiffs advertise, that all carriers are evil and out to get, every consumer, and they're always going to offer you lower, essentially saying that by de facto that every carrier handles every claim unrepresented in bad faith. Which it's a standard that we have to be reasonable. You can't, fail to settle claims that you should. You have to look out for your insured's best interest. But it is supposed to be a way to essentially keep carriers from doing acts that are against their insured. So, like I said, it's supposed to punish, but it's no longer seems like that's the what it's being used for.
Right. I always think of the ads that there's some person laid up in the hospital with a full body bandage or whatever, and the insurance person's the insurance person said, sign this for $50 and you'll never sue us. I think people think that happens in every case, and there's someone just stationed at the hospital, like trying to do away with claims before they become claims.
I saw a commercial just like that. What was it called? It was like swoop and settle. That's what they called it.
Swoop and settle.
Swoop and settle. That's what it was. Literally what you're describing. I think it was a commercial and then maybe a billboard. And what it showed was that an insurance person would come in the cloak of night. Probably I don't think they were wearing it, but I think assuming like a trench coat and a hat, coming in with a check for $50 for a claim worth millions of dollars. And don't allow the insurance company to swoop in and settle the claim. Swoop and settle. So I've seen exactly what you're describing, and it's.
This sounds so Florida. Was this Florida? Is this a regional thing?
It sounds very Florida.
My wife's family's from there, and I always am amazed by the billboards and the the advertisements and stuff. It really is a magical place.
Yes.
Oh yeah, that's the best way to describe it. I'll leave it in magical.
Yeah, yeah. So Matt, you were talking about you've seen some pleadings look the same as other pleadings. If you, I mean, give an example of like you saw something like, man, I know they got this from another firm, or I know that someone just this just won at a hearing, so they're going to put this down everywhere.
I remember the COVID complaints all looked very similar.
Okay.
At least when I first saw them getting filed.
Mhm.
So when they first started to pop up, and now granted in Florida, you could file a COVID claim, but where is it going to go?
Right.
We have the small immunity, but I remember seeing plenty of complaints start to look very similar. And then there was one complaint out in Miami against a supermarket chain that beat a motion to dismiss. And I didn't follow much after, but I would have to assume that complaint especially made its way across the state of Florida.
Mhm.
But yeah, I mean, like, Corbin, I think you nailed it tremendously. Like, it truly is this collaborative effort that we just, well, I can't say we anymore, but at least defense counsel generally just don't adhere to. They have to collaborate in order to combat the fear of bad faith or an adverse judgment that's just way out of left field. So I'm
Right.
with it, man.
That's stuff's part. Got to find a way to collaborate.
Yeah, and after, it's funny, after there's a big Pennsylvania Supreme Court decision or Superior Court decision, you'll see the plaintiffs' bars. One thing that comes to mind is discovery requests. The plaintiffs' bar will automatically start asking for things that have been deemed constitutional and relevant and discoverable in every discovery request across the board, unless it's a really podunky, excuse me, but small plaintiffs' firm, whatever. But the big players will all just start adding that the next week. And on the defense side, and I can think about like insurance coverage. You know, a Philadelphia court said you can see beyond the declaration pages in certain instances, and so everyone asks for the full policies and exclusions, everything. On the defense side, one of the things that we're incorporating in our discovery requests more and more is, do you have a third-party funding source? So I mean, I don't know if you have them, and so Pennsylvania just said you can ask for that, and you get that. Well, it's been months and months, and we've incorporated them as in most of our discovery requests, but I've never seen one from it. I mean, there's no big meeting we're having.
Yeah.
We're just doing this all when everyone individually recognizes it. You know what I mean? And that's not the way to do it.
I don't think I've ever seen a litigation funding style discovery request, at least in a state court. I'm sure it exists. And I'll admit it candidly on this podcast, I don't know if that's authorized under Florida law, if I can discover a litigation funding agreement.
Right. Well, then there's some implications. You can make some arguments that if there is, there's certain things that are implicated there, but we just want to know.
Yep.
And they of course object to it, and we can fight it or not. Depends on the circumstances. But I'm just, it's funny that a ruling comes down and the plaintiff's bar assimilates it. They're on it. They have the listserv. I'm sure they have like meetings in basements. Plaintiff's attorney or defense attorneys are all kind of like on their own island. They're within their own firm, but there's no like, even like big conferences like DRI and stuff. I don't see people getting into breakout rooms and really getting in the nitty gritty of stuff. Maybe there's just too many of us or too many different types of claims. Or what.
So firms won't even speak internally. You'll have a lot of big insurance defense related firms that are siloed within silos. So you'll have like, this is my practice group.
Yeah.
That's based out of X that only does X type of claims. They won't speak to, office B, who's still in the state, but maybe in a different office, or even, listen, I've seen it as well. I have friends who have told me that they're in big offices in one locality, and practice groups won't speak to each other at all. So you're not even getting collaboration within a firm itself.
Right.
It's like a mindset you have to get through. I feel like the mindset of defense is just, this is my case, this is our case, this is what we do. We've got to get through that. We got to break that threshold.
Yeah.
Otherwise, we're just not going to advance. We're going to get left behind.
Right.
And then continue to pay nuclear verdicts.
Yeah, exactly. Yeah. So what are some other tactics you're seeing, Corbin, in cases that you might not have seen when you were at your previous employers? How's the plaintiffs bar adapting over time, and what new strategies are they using that you're seeing?
I mean, I almost feel like they're using a more, at least for what I've seen. So most of mine is going to be based on my, when I was with James River, when we saw a lot of litigation. It's seeming more and more to me like plaintiffs' counsels just don't care, as in they don't have this fear or pressure, like we were talking about the pressure. And so they're just not negotiating as much as I used to see. I used to see more movement, whereas now, especially in Florida, I would see a lot of, we pay a lot more than case values were actually worth, just for the fear of a verdict in Florida. So it's more to me of a, obviously they're starting that reptile theory,
Mhm.
which is becoming more prevalent. And it's just, I don't know how to describe it. It's almost an I don't care attitude where I know I'm going to get something because I filed litigation. So I know there's money there. It's just a
Mhm.
matter of how much am I going to get from you?
Right.
And
100%.
it's a tough mentality. That is the toughest wall to break through with the plaintiffs' counsels.
I think another thing that occurs is that I just saw one of my friends' firms posted this morning that they got a $12.7 million settlement in a case in Pennsylvania. And it's this
Wow.
attorney that is good friends with my friend at this firm. And I think part of it is, at least in our firm, with our insureds and our clients, we oftentimes have confidentiality agreements in our settlements.
Yep.
So a plaintiff's attorneys can't, well, some of them really push, and sometimes we relent. We say, okay, we agree on. It takes weeks to agree on the language. That one sentence, secured a verdict in this many figures for a woman who had this going on, or man that had this going on.
Mhm.
But if you want to really get business, what's the best way to do that? The best way to do that is to pump up these huge verdicts you've won, and then people get stars in their eyes when they look online, they look at a billboard or whatever. And you don't get that if you settle, right? You only get that if you have the big trial and you bury the person, and you can walk out of the courtroom with all the, I mean, that this really happens, but all the microphones in your face, and you can announce that your person was vindicated. And so I think that, Corbin, if you're looking at building a practice as a plaintiff's attorney, who's going to come to you if you're like, hey, I settled some cases, they're all confidential, but just believe me.
Yeah. Yeah.
versus millions and millions and millions recovered for my client, which you can only pump up if you go to trial.
Yep.
So I think that maybe that's part of it. But the thing is, you have to convince your client to do that. If someone puts up $1 million, you have to say, don't take it, go for 5. And that's tough for some people. I mean, it's like deal or no deal.
Well, I feel like what the plaintiff's bar should be required to do is, when these offers are made or they're in negotiations, they should, I think, be forced to, at least give an idea of this is what you would take home today, compared to if you went to trial and we did get this verdict, and there's no way of really knowing, so it's kind of tough. But this is what the client would actually take home if you did go to trial, because once you file suit, the plaintiff's counsel's fee goes up, the percentage they take goes up, the expenses to litigate goes up. So that's just more money that's being taken. So while you may get a higher verdict 2 or 3 years down the road, your expenses are going to be a lot more. Your fee cut's going to be a lot more. The time that you didn't have that money that you could have put into any kind of investment vehicle to grow, you've lost that time too. So to me, it's almost unethical.
Right.
You feel like you have to have these conversations with your client so they can make the best decision, but that's not what's happening.
Right. When I was a younger, brasher attorney, I used to always ask plaintiffs during their deposition, it's my understanding that the demand is X. Why is that?
Yeah.
And I had objections out the wazoo, but one time, it's amazing. The plaintiff turned the attorney goes, "It's what? I don't want that." And I was like, "Wow, that's wonderful." And they moved to strike that comment and everything. But because especially in New York, I do a lot of work in New York. It's like, some of these cases are slip and falls, soft tissue injuries, 2.5 million. And when you say that, they're like, they know at that moment when you ask the question deposition, you're not really trying to put money in my pocket. You're trying to put money in your pocket. And so anyway, but go ahead, Matt.
Well, I'll say to that, at least a differing opinion on it. I would say probably the cost of healthcare probably plays a part in it as well, right? Like if you have somebody without health insurance treating on an LOP, or a letter of protection, for example, in Florida, I mean, their expenses could be truly they have a knee surgery, a hip replacement, what have you. It could be, I don't know, $200,000, $300,000, $400,000 in medicals that they have to pay. And the plaintiff's attorney is also stuck in the scenario where like, well, I got to try the case. I know the case maybe really isn't worth $450,000, but you're left with no choice, right? Because if you settle for 200, you've got a client who's got, right. I mean, it goes to your point, Corbin, where it's you have a client you're not maybe looking out for because you've created a scenario where they've got such high medicals and you can't settle the case for them. So it's either all or nothing. So I think that maybe plays a part in it as well. At least I've seen it on my side.
Oh yeah, absolutely. I think that's true. So I want to ask you both about nuclear verdicts, because Corbin, you mentioned nuclear verdicts. So I'll start with you. What is a nuclear verdict, and how do you deal with them, and how are they reported to you? How do you talk about them?
So nuclear verdicts are just enormously high verdicts. So verdicts that necessarily wouldn't have are not reasonable, but they're just astronomically high. But they're becoming more reasonable, if that makes sense. Because, you know, does that make sense?
It's the norm.
Yeah, at one point they used to be nuclear verdicts, but now are we just going to call them verdicts because they're just becoming every day? And how do you fight that? And I think there's a couple ways we can fight it. And one is we should start working together as a defense bar so we can try to catch up to plaintiff's bar. I think we need to educate the public on, like I was talking about how the plaintiff's counsel or the plaintiff's bar, they advertise all the time about the negative insurance companies. I think we need some kind of public outreach for the insurance carriers to get out there and show that we are actually helping or trying to help the public. And I think we need to put our foot down on some cases more often, because we get so lost in one claim that, oh, I'll settle this one for a couple $1,000, no big deal. But then add that up over time. And then slowly you start developing where I am getting that mindset, where as a plaintiff's counsel, I'm going to get money. It's just a matter of how much. So they just keep pressing the envelope. And with corporate clients, I'm sure you see it all the time. It's not hard for a jury to convince themselves that I'll just give a pile of money from this big corporation to this little person who's so hurt, and I just can't imagine that they'll survive. And I think we need to find a way. We got to find a way to humanize the corporate client. Instead of using the corporate name, we need to find a way to use the person's name that may be representing the corporation. Just take away that corporate entity's, overarching. And we used to have to do this with Uber all the time. With Uber cases, you don't want Uber in front of the jury. It's just that write a blank check at that point.
Right. And part of that, and Matt, we were talking about Sherry Bellett's, another shout out to her. She runs this course on all these issues, social inflation, and it's really wonderful. And we had her on the podcast recently. But when you humanize the corporate defendant, there's a couple ways to do that. But one major thing is choosing the corporate designee. I mean, that's a huge decision. And, I've left that up to clients on occasion, especially when I first started. Hey, who knows the most about this? They'd say, Tom. Okay, Tom. And Tom would be the corporate designee. And now I vet them not only for their knowledge and whether they meet the notice of deposition criteria, but do they present well? Are they sympathetic? Could I talk to them about, listen, they do care about the hurt plaintiff, they do, but they feel like they need to not. They need to be so objective and so robotic and answer the question. And it's okay to say, I'm sorry this happened to you, but it doesn't mean it's our fault. I mean, you don't need, those are mutually exclusive, right?
Yep.
And so I think that's really important, is to choose the corporate designee and really put a concerted effort into doing that versus just whoever seems to know the most about that topic. Matt, sorry, go ahead.
No, I'd say we would do that from the carrier perspective too, on who we would send to trials.
Right.
Is depending on the plaintiff and the fact cases, we would send certain folks that would would present better for that jury pool.
Right.
So it would be the carriers as well as the corporate designee.
Right. Matt, what ways back in your previous life, what ways did you employ kind of humanizing the corporate?
All those years ago.
Well, yeah, I mean, a week at least. But.
Yeah, see, when people see this, fair point.
Yeah.
All the years back when I was a defense attorney, how I would combat the nuclear verdict
and social inflation and all the things that go along with that.
I tend to agree with what you're saying in terms of the corporate designee. I mean, having somebody who presents like a human is just, I couldn't agree more, is nearly impossible. It used to be, you're right, one or two corporate designees, depending on obviously the topics being presented or what they know. And you could prep anyone effectively to be a corporate representative.
Right.
You're right. It's having someone who truly represents the face of the company that really will change someone's mind. I stand by that firmly, and I couldn't agree with you more.
Right. The problem is if you pick someone who's the nicest, but doesn't know about the topics and notice of depth,
that might be a problem.
Then you're being reimposed. Then you got someone else.
You need a different designee.
Exactly. Well, something we've done in the past, we've produced multiple if there's no one person that can talk. I mean, it's pretty common in Pennsylvania. I don't know if it's common in Florida. But they'll say we want someone. Yeah, usually if in a products case, it's the books and then the product.
Mm-hmm.
So they'll say like there's an asset purchase agreement. So who did the books and who, someone that's a bookkeeper or did accounting. And then there's someone that's like, okay, I designed the product, I'm an engineer, et cetera. And so, that's a little, people try to pigeonhole someone into that. And they'll say, well, you're an engineer, let me teach you accounting in an afternoon or vice versa. I think it's easier just to spread that. I mean, I know it's a pain, but it's easier just to have people in their own lanes,
Mm-hmm.
Yeah, it could, when we would do construction, it'd be the same deal. It'd be like, if there's delay damages, this is the delay guy, and this is the defect guy, or whatever. We would slice and dice depending on those issues. But even still, like, God, have somebody that's personable, that could speak.
Yep.
That's not, you're right, that robotic.
Yeah.
We do nothing wrong. I mean, it's not gonna. Again, shout out to Sherry on this one, because I feel like I'm mirroring what he says.
Well, that's good. That means their training is working, right?
Yeah. Well, again, shout out to Sherry, guys.
Yeah, yeah. So, Corbin, if you do claims in different regions, are you seeing regions that are, I mean, we see it in Philly versus surrounding counties, obviously urban and more liberal areas are higher verdicts, et cetera. But
Yep.
when you get a claim in a certain venue or jurisdiction, does your light bulb go off and be like, oh no, we don't want a jury here for these facts?
There's a few. I mean, Louisiana sticks out.
Mhm.
It's tricky down there. I mean, they have the 1 year prescriptions, or I think they call it prescription down there, where you have 1 year to file suit in Louisiana. So you get a lot of litigation, but at the same time, they have the McDill tender. I don't know if you guys are familiar with McDill tenders.
No.
You have to, in Louisiana, affirmatively tender a reasonable number within 30 days of receiving information. So if you make an offer in Louisiana, you might as well just send the check for that number. Now, this is strictly for first party. So I should preface with that, UIM, first party.
Sure.
But yeah, so the McDill tenders, if it's reasonable, so if I offer 10,000 to settle a claim, I have to either specify that 8,000 of this is for your injuries, and then 2,000 we don't necessarily agree with, but we're going to offer just to kind of settle the case, to kind of cap that you only have to send an $8,000 check. But if you offer it and it's not broken down in that way, you should go ahead and tender that money with no release. It's just sending it to the plaintiff's counsel. So tricky.
And that, so are you in every state? Do you have to know this in every state?
When I was with James River, I handled all 50 states, including Puerto Rico. So I learned a lot about a lot of venues.
Wow. And what is the most, what venue do you love being in the most, and what venue do you hate being in the most? And let me just preface this by saying, Philadelphia's it was just named this year again. We have the great distinction of being the #1 judicial hellhole in America. There's a publication called the Judicial Hellholes. And for plaintiffs' attorneys, it's the best. For defense, it's the worst. For plaintiffs, it's the best in all of America. How about that? So
I'm Googling that.
No, seriously.
Where are we on this?
Judicial hellholes. Yeah, it's Philadelphia's #1.
I'm going to have to write that down.
Yeah. So where is from practice, Corbin? Where do you say you have a claim and you're like, oh, you know what? Good law for us. I'm really excited to do this, versus, oh my God, this is the worst venue I could be in.
So I would say, and this is going to contradict intuition, but I loved Florida mainly because we had such good firms down there.
Oh, cool. All right.
So we had really good firms, and not saying we'd win all the time, obviously, because we didn't, but we had really good firms to help facilitate those cases. So that made it a lot easier for us. And you need good firms down there in Florida to navigate that.
Right.
The worst, man, probably
Don't say
New York.
Pennsylvania. Okay, all right, I can handle that.
Yeah,
I'm in New York a lot, but that's terrible. It's
the New York
venue.
when you get in those 5 boroughs, it gets tough.
Oh man. And they're so the old school plaintiffs attorneys in New York are so methodical because they're so used to winning everything that I've had multiple people that presumably don't know each other, because some are on Long Island, some are in Brooklyn, some are in the Bronx, and they will call me and they say, listen, the lien is this, pain and suffering is this, reasonably. We obviously multiply that by 3. So here's what you should settle for. I mean, I've had multiple people do this stupid 3 times thing, and I don't know where it comes from. I have no clue. But they say pain and suffering is about 100, lien's 50, that's 150, so 450. So let's go. Let's settle it. This is week 1 of the claim. I'm like, whoa, I'm not paying. No one's paying $500,000. I have no clue what's going on here. I have a notice of claim, or I have a complaint, and it's just but I think they're so used to just winning.
Yep, you just get a check. I'm gonna win. Yeah, just what am I gonna get? And I had a case right before I left Selective where we had a video of this man just sitting on the concrete. He just was standing and then sat down and called an ambulance. And it was egregious. It maybe looked like maybe he stumbled, but it looked more like he just slowly sat down. But the plaintiff's counsel would not let it go. He would not dismiss the case. We couldn't even resolve it for a nominal number because it was in the 5 boroughs. It was just a tough venue. Yeah.
And what did you go to trial, or did you settle it?
Oh, actually, I ended up coming over here for it resolved. So.
That's a
No idea.
push you out the door.
Yeah, not-
I had
not
this.
sure.
I had this sitting back like I'm out of here. That's it. I can't do it anymore.
This one's not for me. I gotta go.
That's right. Yeah, that's right. And
That
Matt,
was the reason.
yeah, exactly. Matt, we talked about this, but you said Miami is that way, and the
Yeah.
surrounding area is not so bad.
Miami's like that. Broward's like it gradually gets better as you go north.
Mhm.
I want to tell you, I pulled up the judicial hellhole, and just so, for the record is clear.
Please, if you screwed up, I will. Florida's what?
No, you were on the nose.
Okay.
But to be clear, Florida is a former #1 judicial hellhole.
Oh.
Just so the record is
And
straight.
what are you now? What have you fallen to?
We're on the watch list. We've actually fallen.
That's a great decrease.
Yeah.
Isn't that crazy?
Yeah.
Well, listen, we've seen an affirmative push towards tort reform.
Yeah.
Especially in the first party property realm. It's not perfect, but we're obviously pushing towards, fixing that. It's highly litigious.
Mhm.
We're getting there. We're definitely getting there. Yeah,
So
but
what- Do
again,
you still have the list up there? I want to know. Can you give the people
Yeah.
the list? Yeah, let's go.
all right. Let me go through it. Oh, no,
Philadelphia.
that- All right. #1 is
Back-to-back
Philadelphia
champions.
Court of Common Pleas.
Yeah.
#2 is New York City.
There
3
you
is
go, Colin.
California.
Sounds right.
Okay.
4 is South Carolina asbestos litigation.
Okay.
5 is Louisiana. All right.
Corbin, you're all over
Yes.
this.
Oh yeah, I know these.
6 is Georgia, probably after that bad faith case that came out recently. 7 is the city of St. Louis, Missouri. Shout out to Mike Young. #8 is Cook, Madison, and St. Clair counties, Illinois. And 9 is
Chicago.
Minnesota. Yeah.
Minnesota, just the whole state.
Yeah. The
Really?
entire state.
Wow.
Don't litigate in Minnesota.
Those don't surprise me, except for Minnesota, the state. That's
Yeah.
In South Carolina, asbestos. I don't know what that's. They probably have some bad statute on that.
They're saying it's the court's loose application of venue laws and liability expanding decisions by the Minnesota Supreme Court.
Hmm.
Huh.
Wow,
Huh.
would have never guessed. But yeah, so Corbin, when you receive do you ever talk to plaintiffs or attorneys and you get a settlement value and a jury verdict value, and you just say, you don't agree with it, or you think it's too high, but they're accounting for the nuclear side of things? How does that work?
So I don't see as much on this side anymore.
Okay.
Just we don't. That's more the carrier side to kind of push that envelope. I mean, we may advise that we think it's unreasonable, but
Right.
it's going to be their ultimate decision on settling those cases. So
Right.
yeah, I don't know. Currently, I'm not able to comment on.
I hear you.
Sure.
Yeah.
Matt, do you ever report to a carrier and a broker, perhaps, and maybe a client, and they come back and you get a call immediately, like, oh my God, wait, are you serious? It's going to be that high?
Yeah. Oh yeah. I've done it.
How do you combat that if they question you on that?
Hold strong. The
No.
fear, right? The fear you always have is you underreport or you
Right.
Yeah.
you try to be a people pleaser on that front. And you're like, oh
Right.
yeah, we're gonna get out of here, right? And then Corbin, right? You get hit with the nuclear verdict, and they look at the attorney and say, well, you reported pretty low for quite some time.
Yeah.
You're like, that's that fourth quarter report that changes
Right.
the number at the last minute.
I think really it started with setting that precedent at the beginning. If we do end up at trial, there's a chance that we're going to get hit with this outlandish verdict that
Yep.
would not be expected, that I can't account for,
Right.
especially in today's landscape and
Yep.
especially Florida.
Yeah, exactly. Yeah. And what we've started doing, we do a comprehensive lit plan within 60 days usually. And it seems early to people when I tell people that, like, how do you know everything in 60 days? Well, we don't, but we project as much as we can going forward. And some of these lit plans are 40 pages, some are 8 pages, but it depends on how in-depth the case is. What we've started to do is we always put a jury verdict, we call it pure exposure, and we put in there a settlement value. And what we used to do is we would say the case is worth this, I think it's settlement, this at trial. Then we started expanding those ranges, and they got ridiculous because it's true. If the plaintiff is likable and all these things happen and the lien is such and such or whatever, then it's 5 million and it could be worth 1 million, and that's too broad. So what we started to do is give 2 ranges for each. If the best case scenario goes our way and discovery looks good, the plaintiff is not likable, it's this little range. If all this stuff goes bad, it's this bigger range, and we do that for both. And it seems when we revert back a year later or 2 years later, right on the eve of trial or pre-trial motion phase, we're pretty right. You start checking things and you're like, wow, you know what? All these things went bad and it was that higher range. Wow, unbelievable. And so it's cool to see that, to be like to have the experience behind you to do that. Matt, you're looking at me like you in disbelief, like you don't think I'm the prophet. I think I say I am.
I think you are 100% the prophet, Nate.
Prophet Nate was in the
I-
Bible. You know that. There's a prophet named Nathan.
Was he?
Yeah.
Nathan. Yeah.
I'm a Jewish guy. I don't know. I'm sorry.
Yeah. Yeah, I was named after the prophet Nathan. My mom was really,
Were you really?
Prophet Nathan. Yeah. Mhm.
Well,
Corbin knew.
listen, you were
Oh, I was named after an airplane.
No, you were named after Corbin Dallas. You were
Oh,
named
yeah.
after
Yeah,
Bruce
Corbin
Willis
Dallas.
in Fifth Element. Yeah.
Bingo. That's me.
Yeah.
great.
But
Well,
no,
I mean, look,
it's-
Nate, I respect it. I respect the way you report. That's how everyone should report, and it sounds like you get great results as a result of it.
Well, thank you. Yeah, I mean, we're not always dead on, but I mean, I think it's good to show that and be like, listen, this case you go one of two ways. We want to basically tell people that are managing risk or looking at claims, there's a million ways this can go. This could spiral out this way, spiral out that way. And we have cases where you know this, Matt, and Corbin, you too. Everything goes perfectly. The plaintiff is
Yeah.
super unlikable.
Yep.
Their story stinks. Damages aren't as bad. And it's great. And you just see the value decreasing. And we've had cases go the completely opposite way. And just we lose every hearing, we lose every motion. And it's just like, we're just like, oh my God, I can't. But we don't want to do that if we've talked about here. We don't want to say, hey, it's worth this and end up here.
Yeah.
Yep.
We want to make sure that they know that's a possibility. So that's what we try to do at least.
Yeah.
But anyway, so
I think
Respect.
maybe that's what the defense bar
Defense bar
needs to be more affirmative or
Yeah.
more instead of reactionary. We need to be, pushing the envelope and being, in front of these things instead of just reacting to them like tends to happen.
right. And I think, Corbin, you made a good point. You said, if we settle all these little cases that look like they're small, two things. Well, you said one thing happens, which is the aggregation of those is a lot of money. A bunch of 10,000s is a lot.
Yep.
But the second thing is these people, I think, speak amongst themselves. And oftentimes when we do our background work on plaintiffs, we'll say, well, their cousin, uncle, and sister all settled cases recently for $15,000. So they just look at that as kind of a, if those people got it, I can get it.
Yep.
I have the same kind of injury. We're in the same venue. I think if you just keep settling and settling and settling, I think it makes sense financially in the short term, but over the long term, are you welcoming more litigation?
Yeah. You're creating
Energy
precedent.
work.
Yeah.
Yep.
Yeah. Well, there you go. Perfect. I've solved the world's problems.
Boom.
So,
Easy.
so
Done.
Profit Nate.
Yeah,
Okay.
Killing it.
thanks.
You don't even need us.
Exactly. I'll just do the podcast myself. No, we can wrap up. I know it's been about an hour, but Corbin and Matt, thank you so much for being here.
You did.
We'll let you know when this comes out, and best luck to everyone. And hopefully, like you said, Corbin, the defense bar coalesces a little bit and collaborates a little bit more, and we move forward that way.
Got to find a way.
So, yeah.
I appreciate it.
Can I make a T-shirt that says "Profit Nate, the profit of liability"? Is that possible?
Yes, but as long as you do two things. One, Prophet Nathan, because my mom would have a connection.
All right.
And
Fair point.
two, we'll do like a Kevin Leary Shark Tank deal with licensing. Can we do that? That's like
In
10%
perpetuity?
of,
Is that what you want?
no, just until your kid's born. When's that?
Yeah.
Until your kid's born. When was your wife due?
She's doing December.
Okay, so a couple months. I'll save up. I'll get some money for Christmas for presents. But thank you.
Why are you a
So-
defense attorney? You're clearly a shark.
Yeah.
My wife and I love that show. Anyway.
Guys, it was a
thanks-
pleasure. It's always a
Yeah,
blast
thanks so
to
much.
do.
Yeah.
Thanks so
It's a
much.
pleasure. Thanks, guys.